Good afternoon, everyone. We are going to go ahead and get started to keep on schedule. Today, we're going to focus on the value-based provisions in the Stark and anti-kickback new final rules. There's other material in those rules that we're not going to have time to cover today, but if you're interested in more information about those, keep an eye on Holland & Hart's website. We will have additional webinars from our healthcare team that will cover those additional provisions of the rules. One item, go ahead and save your questions until the end of the webinar. We have a lot of material to cover today, and we want to make sure to get through all of that. So a little bit about me. My name is Amber Ellis. I'm one of the attorneys with Holland & Hart's healthcare team. I represent healthcare providers, hospitals, physicians, and others, and my goal is always to help folks move through all of this regulatory language so that they can focus on patient care, which is really why folks have entered the healthcare field. And I will let Jay introduce himself.
Yes, thank you. My name is Jay DeVoy. I'm also an attorney at Holland & Hart. I'm in our Las Vegas office. Our practice here focuses on representing providers, their facilities such as surgery centers and hospitals. And the presentation today is interesting because it's one of what I would consider a pure healthcare issue, as opposed to other areas where healthcare seems to come up often, such as affecting employment and real estate transactions. So this is very interesting because it's looking at the entire relationship, specifically with payers and with other providers, such as large groups that might want to enter into an agreement that previously was very thorny and created a lot of problems under the names of, for example, gain sharing, which was a very controversial topic for a number of years. So we're really looking forward to making this presentation today about these issues and the way that it opens up new frontiers for provider groups and facilities to work with one another, to work with payers, and to loop in difficult to find and small group specialties to focus on patient care.
So before we dive in, this presentation is for general information and educational purposes. It is not meant to convey any legal advice or establish an attorney-client relationship. If after this presentation you have some specific questions, go ahead and reach out to your own legal counsel. So high level, we're going to start out by going over Stark and the potential penalties and the anti-kickback statute. We'll then spend a little bit of time on the new definitions. Those are something you'll want to spend some time studying on your own as well. We'll touch on the three primary new categories of value-based exceptions and safe harbors, and then we'll compare and contrast some of the differences in the sort of corollaries of those three categories between Stark and AKS, although you'll see there are some significant distinctions between each of those sets. So Stark law generally, the physician self-referral law, which is commonly called Stark, prohibits physicians from referring patients to receive any designated health services that are payable by Medicare or Medicaid from any entity with which that physician or an immediate family member has a financial relationship, and unless an exception applies. Now, this is kind of a funny way to set up a law. Most of our laws that prohibit specific conduct, so criminal conduct or conduct or tort conduct, those laws say if you do this thing with these specific elements, that is a crime or a tort or other violation. And the Stark law is sort of the inverse of that. It says no financial relationships with physicians if you're getting referrals, unless you happen to fit into this specific particular exception. So it's in order to go forward and have financial relationships with physicians, you must specifically adhere to one of the exceptions in the statute. Now, to make it a little more complicated, it is a strict liability law, which means there is no proof of intent that is required to establish liability or non-adherence. And so you really have to pay attention to which exception you are invoking for a particular arrangement and meet all of the miscellaneous provisions to make sure that that exception is fulfilled. Now, the reason behind the law, the reason it was originally passed in 1989 is in order to make sure that referrals are based on the best interest of patients, to avoid a physician referring to themselves instead of making a referral to the proper provider, which is in the best interest of the patient, to avoid overutilization, and other forms of fraud and abuse. So those are all really good reasons to create this law. It's just become a little bit of a Frankenstein. There's so many provisions and exceptions. So let's look at a couple of those. Here are some of the more commonly used exceptions under Stark that are related to compensation arrangements. So I think some of you are probably familiar to folks. Employment and personal services exceptions, space or equipment leases, and timeshares. Those are commonly invoked. The new exceptions are over on the right-hand side. So value-based arrangements, full financial risk value-based arrangements, meaningful downside risk, cybersecurity, and limited remuneration. Those are new with these new rules. We're going to focus on the 3 value-based exceptions today. The others you can catch in a later webinar. Here's a few of the ownership Stark exceptions. There were some modifications made to these in the new rules. We're not going to be going over those today, so go ahead and take a look in your own time. So penalties under Stark, they are pretty harsh. Fundamentally, it's a payment statute. If there are services that are provided through an arrangement where there is an improper referral, payment cannot be made under a federal health care payment program. If those payments are inadvertently made, they need to be returned within 60 days. There are also a number of penalties, and these have recently been increased. So currently, as adjusted for inflation, $25,820 per claim. So that can add up really quickly if there is an improper arrangement in place for weeks or months. That's going to be every single claim that was submitted will be subject to this penalty. So it can quickly become millions, and we've seen that in some of the enforcement actions. Other penalties that are quite serious: exclusion from participation in federal health care programs, liability under the AKS and the False Claims Act, which is a thorny statute and has both criminal and civil liability. And that act can subject you to repayment and triple damages. And that is an area that is subject to key TAM and whistleblower claims. So that's something to be aware of as well.
Turning to the Anti-kickback statute, it's an intent-based statute, and it's found in a different part of the Social Security Act, whereas the Stark Law, as Amber mentioned, is a payment statute. It's found with the other payment statutes under Section 1395 and the various alphabetized variations of it. The Anti-kickback statute is found in a completely separate part of the statute that has to do with other threshold requirements, and it immediately follows the civil monetary penalties law. The Anti-kickback statute, and specifically the relevant portion of it under subpart B, penalizes any intentional action to offer, make a payment, to solicit a payment, or to receive a payment for the referral of healthcare services. Now, what constitutes a payment is anything. It could be in-kind services, it could be cash, and that comes up a little bit later in our presentation in terms of the distinction between when you can make these payments that will qualify for a safe harbor to the Anti-kickback statute, or whether it's for cash payment or if it would be for in-kind services that are covered. But the purpose of the Anti-kickback statute, which is a criminal statute, requires an intentional act, is it prohibits any form of remuneration in exchange for referrals or other federal health care program business, even if it's not a referral, such as durable medical equipment, such as leg braces, spinal implants, spine screws, orthotics, and it's by any person or entity. What makes it distinct from the Stark Law, although the Stark Law is strict liability, is different in that respect, it also has a much narrower scope, and it affects physicians making referrals, and even then only for specific healthcare services such as inpatient or outpatient hospital services, physical therapy, hospice, and things of that nature. The Anti-kickback statute applies to anything that's paid for by Medicare, Medicaid, or other federal programs such as TRICARE for people who live in jurisdictions with a significant population of people who are active duty service members or military retirees. The standard that's been enunciated by the courts is that if any one purpose of the payment is to induce the referral of services for federal health care paid business, it implicates the anti-kickback statute. Now, there's been a lot of Supreme Court precedent on this issue. Given the relatively small number of cases that the U.S. Supreme Court puts out every single year, the fact that the False Claims Act, and specifically as it applies to the anti-kickback statute and healthcare claims, comes up over and over again, indicates a pretty strong judicial interest in the statute, and something that is the subject of a lot of attention, and something that I predict will become the subject of even more attention in the coming years as the presumptive nominee for the future head of the Department of Health and Human Services is going to be leaving his role as the California Attorney General. So that the standard that's been enunciated in the most recent Supreme Court decision, which is known as the Escobar decision, is generally beyond the scope of our discussion today, is the materiality of a misstatement made for a false certification for these kind of healthcare services would be if the statement is false and the government would have treated the payment claim differently had it known that the statement was false, then it triggers liability under the anti-kickback statute if the purpose of it, just one purpose of it, was to influence the referral of federal healthcare business. There are safe harbors to the anti-kickback statute because, taken to its logical extent, anything is a payment to try to influence healthcare business, whether it's having employees who want to promote your business or paying your landlord who has a vested incentive to make sure that your business succeeds. So what happened is the Department of Health and Human Services created a number of safe harbors that are voluntary and must be fully satisfied in order to immunize a specific financial transaction from even potential liability under the anti-kickback statute. And as we go to the next slide, you can see there are many of them. I would say even more than there are for Stark, but that's necessary because Stark is fundamentally more limited in scope, and the anti-kickback statute potentially implicates all aspects of the healthcare practices financial relationships. So there are a lot of things that are applied to essentially every practice, such as exceptions for small and large investments, such as publicly traded companies, smaller medical clinics, bona fide employment, relationships with contractors, and leasing of equipment or for office space. And then some of it gets much more specific, such as subsidies for obstetric malpractice insurance, cybersecurity, which is a brand new safe harbor that we won't be talking about today, but is an interesting addition and ties to the prior safe harbor for incentives and other subsidies that were available for healthcare information technology payments that could be made by a vendor to a practice without violating the anti-kickback statute. So in your spare time, you might want to look over these and make sure you understand them to the extent that they affect your practice or the practice of your clients, and understand some of the things that could apply here. A lot of these were left unchanged by the most recent final rule, and some of the things that most of what we're going to be discussing today are brand new additions. There was only one of these existing, one of the older safe harbors that was significantly changed by the most recent final rule, and that is the personal services contract, which now allows for outcomes-based payments along the lines of the value-based agreements we'll be discussing today. The penalties for violation of the anti-kickback statute were significantly increased in 2018 as part of a congressional budget bill. A lot of the penalties were increased by a factor of 2. Some of them were even quadrupled. So the criminal fines that are available and will be subject to inflation and increase in the future were increased from $25,000 to $100,000 per violation. There's civil penalties that, as noted in the slide, are already subject to inflation and exceed $100,000. The jail term was increased from 5 years to 10 years for violation of the anti-kickback statute. And similar to what Amber discussed, a violation of the anti-kickback statute creates liability under the False Claims Act. And that opens up a whole separate door for people to bring these qui tam or relator actions where they file a lawsuit on behalf of the United States government and get a whole range of other benefits, including attorney's fees, treble damages, which are the amount of the kickback multiplied by 3, or tripled or trebled, and a range of other kind of penalties that would be available for the prosecution of those actions. And this also bookends to the statute I mentioned previously called the Civil Monetary Penalties Law. And the difference with the PL is that purely has to do with civil remedies for similar violations. The statutes really work hand in hand, where conduct that is outside the scope of the Stark Law but isn't the specific criminal activity that's prohibited by the anti-kickback statute is something that could be addressed with civil penalties that are remediable through the civil military penalties law, which are very similar to the anti-kickback statute but don't carry the threat of jail time, but as a result of that, have a wider sweep. So the CMPL is important, although unfortunately beyond the scope of what we're discussing today, because it can capture so much more conduct that seems like things that would be contrary to the intent of the anti-kickback statute, but aren't specifically prohibited by it.
So the new exceptions that we're going to be talking about today have arisen in part because for years stakeholders have been raising concerns about the unintended consequences of Stark and AKS. Those laws and the regulations implementing them were developed in a fee-for-service payment environment where in exchange for a service, a particular fee is paid. The exceptions that were, the older exceptions that we were previously discussing were developed to protect patients who were receiving care in that sort of an environment. And unfortunately, stakeholders were perceiving those exceptions to have somewhat of a chilling effect on innovation in healthcare. And because in order to transition to value-based care, cooperating and coming up with innovative ideas on how best to move to value-based care are essential, there were concerns that that was really going to inhibit any of that growth. So these new value-based care models have been long awaited in some sense, and I think the first thing we'll want to talk about are the value-based terms and the definitions that have come down to sort of set the landscape for this environment. So essentially there's 6 new terms. They actually exist in both Stark and AKS, and they're going to be important to really dig in and understand because they have very particular meanings. There are additionally some new terms under the AKS. 4 of the terms are identical to Stark. There are 2 of the 6 that I just mentioned that are a little bit different under the AKS, and we'll talk about them more as we hit those slides. And then for purposes of the coordination and management of care exception, there is a particular definition there as well. And we'll talk about these a little more as we look at the relevant exceptions. So first, value-based activity. So this is one of the 6 that is slightly different under the AKS. So a value-based activity is any activity that is reasonably designed to achieve at least one of the value-based purposes of the value-based enterprise. And there's a bunch of defined terms in that sentence, so you'll have to cross-reference. So the provision of an item or service, the taking of an action, or the refraining from taking an action. And so one of the examples of an inaction that may be a value-based activity would be, for example, if there is a new and updated medically appropriate care protocol that, for example, reduces the number of required steps in a given procedure. A participant might refrain from ordering particular items or services that would have been provided in those newly omitted steps. So that inaction could be a value-based activity. Now, the difference in AKS is that it does not include the making of a referral. Under the Stark exceptions, there is an allowance for making a referral for the target patient population that we'll discuss a little more when we get to those exceptions. So a value-based arrangement. It's an arrangement for the provision of at least one value-based activity for a target patient population. Again, multiple newly defined terms in the definition. And I think the key is that all the parties to the value-based arrangement must be value-based enterprise participants in the same enterprise. And this is the same between the 2 final rules. Value-based enterprise is two or more VBE participants who are collaborating to achieve at least one value-based purpose. They all need to be a party to a value-based arrangement with the other, and they must have an accountable body or person responsible for the financial and operational oversight, and a governing document that describes the value-based enterprise and how the the VBE participants intend to achieve its value-based purpose. So it doesn't need to be a separate corporate entity. That's one thing worth noting. This can exist through some contractual arrangements. Another item worth noting is that VBE participants can join and leave a particular VBE throughout the VBE's existence, but at any given time, the VBE must have at least two or more participants in order to meet this definition. Another item worth mentioning is the comments to the proposed rules. There were some strong opinions on this requirement that the VBE have an accountable body or person responsible for the financial and operational oversight. And ultimately, the regulators did land on this instead of adding additional elements of oversight or removing the requirement. And they reasoned that, while an accountable body might make more sense for a larger VBE, a single person may make sense in a smaller VBE. And one item to sort of foreshadow what we'll see in the AKS, for purposes of the full financial risk safe harbor, there is an additional requirement to provide quality assurance program, and there's some rationale behind why that would need to occur in that particular safe harbor. And that's something Jay will touch on a little bit later in this presentation. So value-based purpose, there's four options: coordinating and managing care, improving the quality of care, appropriately reducing the costs to, or growth in expenditures of payers without reducing the quality of care. So the quality of care needs to hold steady. And then finally, transitioning from healthcare delivery and payment based on volume to quality of care and control of costs. A couple of items: hospital saving money or VBE saving money is not enough to qualify as a value-based purpose. There has to be this link to quality of care. And then one item that comes up a little later, it is not required that the parties actually achieve the value-based purpose. Instead, the value-based activities, and you'll see this in the definition for value-based activities, must be reasonably designed to achieve. Now, I say that, but when we're actually looking at some of these exceptions, there's some additional monitoring requirements which require organizations to monitor and potentially pivot mid-arrangement depending on whether or not they're making steps toward value-based activities and outcome measures specifically. Both of those items are addressed in the monitoring requirements, and we'll talk more about that in a moment. VBE participant, there's two definitions. They're slightly different under the AKS and STARK. Under STARK, it's a person or an entity that engages in at least one value-based activity, and under AKS, it is an individual or entity. And the reason for the word individual, it's meant to capture physicians, nurses, and other practitioners, providers or suppliers who are in the healthcare environment involved in caring for patients. That's the explanation for why that's a different word there. And then the other difference in AKS is that it does not allow a VBE participant to be a patient acting in their capacity as a patient. So look to the patient engagement and support safe harbor if there's going to be any sort of remuneration to patients instead. There is not a role for them to play in the value-based safe harbor. Finally, target patient population. It's an identified patient population selected by the enterprise based on legitimate and verifiable criteria. It needs to be set out in writing in advance of the commencement of the arrangement and further the value-based enterprise's value-based purposes. So there's a lot of interconnectedness amongst these definitions. A couple examples of what might be a target patient population. So if the value-based enterprise wants to enhance usage and access to primary care services, they could say that it's patients in a particular zip code or county of residence. An alternative might be if there is a goal to boost pediatric vaccination rates in a particular community, your target population could be patients under the age of 18 with a household income below 200% of the federal poverty level. So those are just some examples that were pointed out in the proposed rules and the final rules with respect to what this might look like.
So one of the new additions that was made as well in terms of value-based arrangements that was going to qualify for a safe harbor under the anti-kickback statute are CMS-sponsored models. And this largely has to do with the Centers for Medicare and Medicaid Innovation, which is an office within CMS. They were largely responsible for reconfiguring MIPS and MACRA several years ago, and helping that be and rather remain a budget-neutral change to the rules in order to incentivize certain activities by reapportioning payments among practices and individual practitioners who are participating in the program to the extent where people who were or practices that were adopting certain technological measures and other reporting activities were receiving increased payments. But the downside was that they came at the expense of the practices that were doing things like not submitting their records electronically, not sharing this information, some of which were receiving a 4% or more reduction right off the top with their compensation, which for any business owner is very significant, and they had a lot of pretty noticeable consequences for the practices and the practitioners involved. So one of the safe harbors that was created by the final rule is that for payment models that are being tested, and it refers to the relevant sections of the Social Security Act, but basically the takeaway is that the Medicare Shared Savings Program that was created by CMMI, and then potentially in the future other pilot programs or other programs that are being tested by CMMI will qualify for the safe harbor so that practices don't have to go back and potentially have to reconfigure their relationships in order to participate. And it also prevents the need for Congress or the Department of Health and Human Services to get involved and create these program-specific waivers as has happened in the past. So this is designed to be a catch-all. The idea is to incentivize more innovation from CMMI and not require quite as much coordination and therefore potential delay among government offices and potentially multiple branches of government to create the kind of environment necessary to share this information and to allow these kind of programs to be promptly implemented and to reach practitioners and see what the effect is going to be on the populations that are receiving treatment under them.
All right, so moving to the new exceptions themselves. Speaking of the Stark exceptions specifically, they're referred to under the rules as arrangements that facilitate value-based healthcare delivery and payment. These do apply to both monetary and in-kind remuneration, and that's different from all the exceptions under the AKS, as you'll learn. All three of these new exceptions under Stark include certain core requirements that you're going to see over and over. The first is that the payments are for or result from value-based activities undertaken by the recipient. The remuneration can't be an inducement to reduce or limit medically necessary care. The remuneration is not conditioned on referrals of patients who are not part of the target patient population or business outside of the value-based arrangement. If the remuneration to the physician is conditioned on referrals to a particular provider, there must be certain elements met, which we'll see, and that includes patient choice will always trump that referral requirement. And then finally, there's some record-keeping requirements that we'll see. Just generally, what you'll notice is the more risk a value-based enterprise puts itself at, the greater the financial risk, the fewer written requirements and other sort of red tape they must adhere to. And the rationale is that some of the concerns that led to the original regulations and particular exceptions that were placed in these regulations are mitigated by the fact that the enterprise is at financial risk. So the risk of overutilization, for example. If the enterprise is fully at risk for the patient's care, that mitigates overutilization and overtesting. So we'll start with full financial risk. So the full financial risk exception requires that the particular VBE is at full financial risk for the duration of the arrangement. Now, one item worth noting is that it qualifies if it's contractually obligated to become full financially at risk within 12 months following the commencement of the arrangement. So there's a little bit of a ramp-up period allowing for that adjustment period on the front end only to come into effect. Full financial risk means that the VBE is financially responsible on a prospective basis for the cost of all patient care items and services that are covered by the applicable payor for the patients in the target patient population for the period of the arrangement. And prospective basis does mean that it is they've assumed this financial responsibility before they have started providing that patient care. And so some examples of what full financial risk might look like. There could be a capitated payment where they're paying on a predetermined amount per patient per month for a period of time, the period of the arrangement, or it could be a global budget payment from a payor that is meant to compensate the enterprise for providing all of the patient care for a certain period of time. They didn't settle on a particular methodology that must be followed. They allowed some flexibility, but the idea is that it would be for all of the patients in that population for the specified period of time. Here's some more of those core requirements that we'll see repeatedly in the Stark exceptions. The remuneration is from the value-based activities that were undertaken by the recipient. The remuneration is not an inducement to reduce or limit medically necessary items. And it's not conditioned on referrals of patients who are not part of a target patient population. The records for the methodology and the actual amount of remuneration paid must be maintained for 6 years. So you may come up with the methodology up front and then document the actual amount that was paid as the arrangement proceeds. Finally, if there is remuneration paid that's conditioned upon referrals of the target patient population, that must be set forth in assigned writing, and there must be an understanding that that requirement does not apply if the patient expresses a different patient preference or if the patient's insurer or physician determines that it's not in the patient's best interests.
There's very similar requirements under the anti-kickback statute. The value-based arrangement has 9 requirements that have to ultimately be satisfied, many of which align with the Stark law, which isn't always the case, but is very true with these new obligations. And some of the other requirements that have to be met to satisfy the anti-kickback statute fall in line with a lot of the other safe harbors. The terms are fairly standard, especially for these contractual relationships, such as it has to be for a duration of at least 1 year. It has to be in writing, signed by the parties, and it can't take into account the volume or value of referrals for business that is paid for by a federal healthcare program. But there are a number of new requirements that we'll go over briefly. The most important one that applies to these full financial risk relationships, as well as to other relationships where there's downside risk that we'll talk about later, is that there's a class of people who are going to be excluded from it, and it's identified here on this current slide. And the entities that can't participate in the full financial risk arrangement include pharmaceutical manufacturers, distributors and wholesalers, pharmacy benefit managers, medical laboratory companies, pharmacies that are primarily compounding pharmacies, DME providers such as, well, not just DME providers, but any medical supply manufacturer that may or may not be DME, such as implants, orthotics, prosthetics, and then any individual entity that sells or rents DME. So that could be a physician-owned distributor, which is its own kind of area of legal complication, but even for other distributors or wholesalers or renters of certain equipment, they can't participate either. And once you get beyond that and those other areas that have special treatment under the Medicare laws and their own reimbursement requirements, the entities that can participate generally are tended to be facilities, healthcare practice groups, and then other affiliated groups such as, for example, a physical therapy practice, which isn't quite the same as a medical practice, but can be integrated in the scope of working within these VBE requirements and working as part of this broader organization to deliver care to patients. But as Amber noted, a lot of these trends are things that have been in place for a while with these global payments and the full financial risk of somebody providing for an entire continuum of care for a defined population, whether it's within a specific zip code or a census tract, or with certain payers, they'll identify certain patients that have episodes of care that will be covered by this. And episodic care is something that can qualify for one of the other arrangements that we'll be discussing shortly. But for here, episodic care is very common where you'll have a payer agree to pay a certain global payment for a period of time, and regardless of how much or how little the ultimate patient uses in terms of healthcare services, that's the max amount of compensation that the healthcare provider is going to receive, and whether or not they lose money or make profit on it is completely dependent on the provider, and they're taking all of that risk. So this is a safe harbor that is oriented towards that arrangement, and it provides certain safe harbors, not just safe harbors, but also guidelines to ensure that the providers that are receiving this payment have proper policies and procedures in place to ultimately protect the patient and make sure that there isn't a misallocation of federal health care funds. So this next slide is primarily the terms and conditions for the safe harbor that are common to other anti-kickback statute safe harbors. For example, the VBE on its own and through a participant has entered into a written agreement to accept full financial risk from a payer for a 1-year period. The writing has to contain all the material terms, which must include the value-based activity or activities that are going to be provided, the duration of the agreement, and it has to be signed by the parties. The VBE participant cannot claim payment for a payer for items or services covered under the contract or value-based arrangement between the VBE and the payer. So what that ends up meaning is that there cannot be any kind of payment that's paid separately than the amount of money that's given under the contract. So there isn't an ability to have a true-up, because that wouldn't be full financial risk. That would be one of the reduced risk arrangements that we're going to be talking about later in the presentations that limit downside risk, and there still is some downside risk, but the idea is that if there's an ability here for a provider or another VBE participant to seek additional compensation above and beyond what they've been provided under the contract, it defeats the purpose of it being full financial risk. So it takes away that safety net, and that is a mandatory requirement for compliance with the safe harbor. Additionally, the remuneration has to be connected to one or more value-based purposes. It cannot include the offer or receipt of ownership interest in an entity or distributions arising from the same, and that's significant for entities that physicians can still own. The ACA in various states have taken action against physician ownership of hospitals, but it's fairly common for physicians to own other facilities. The safe harbors, the anti-kickback statute specifically contemplate a wide range of physicians having ownership interests in ambulatory surgery centers. So the remuneration has to be based on what the terms of the contract are, and not any kind of side deals or side letters where there's an ability for a physician or another group to invest in some other kind of healthcare facility, or, for example, a large office building that is primarily renting out medical office space and giving distributions based on the rental income that it derives. So there are a number of different opportunities for that kind of income to arrive, especially in more mature markets with more competition, and also where there's a lot more real estate investment in particular stands out is an opportunity where this might come up. So that at first glance does not seem obvious how it would play into that relationship, but in other cities such as the East Coast and especially in the South, such as in Texas and Florida, it's a common issue that comes up where there are numerous different avenues for healthcare investment, healthcare adjacent investment that can return that kind of remuneration that is contemplated by this requirement within the safe harbor. And then finally, there's a restriction that the amount of money that's given under the full financial risk arrangement can't be used for marketing of the value-based enterprise or for services that are covered by the value-based enterprise. So it can't be used to capture new patients. It can't be used to try to market to them. The compensation is solely to be used for the provision of services. And that can potentially raise some issues down the line because theoretically all of the money that comes in from the provision of medical services goes into the practice and can be used for any number of different purposes, which can include marketing services. But when the point comes of having to contract around this issue, just adding something in the contract that says the funds must be used or must be paid to the practice specifically for the provision of these services, and they can't be diverted specifically to marketing activities. So once it goes into the company, if it's going to be used for normal operations, I think that at that point, as long as there isn't a line tying the payment of these funds under the full financial risk arrangement to the provider's marketing activities or their ability to try to market to the target patient population, that should be fine in terms of compliance with that. But that is an issue that I expect to come up in the future and would expect to see some negotiation arise over in the future as well. And then for the remainder of the requirements for this safe harbor of the anti-kickback statute, the arrangement can't induce parties to reduce or limit medically necessary items or services provided to the patient. That's similar to the requirements that are contained within the civil monetary penalty laws. The remuneration can't take into account the volume or value of referrals. That's also very standard in terms of other similar safe harbors under the anti-kickback statute. And then the requirements that are incumbent upon the value-based enterprise and its participants are under these subheadings 8 and 9, namely there has to be a quality assurance program to protect against underutilization and assess the quality of care rendered to target patient populations. Namely, the concern that CMS has and the Department of Health and Human Services has here and has had historically is that they do not want cost savings to come at the expense of patient care. So as Amber mentioned previously, the goal is if you want to hold the line to reduce expenses, it can't come at the expense of withholding care to patients or diminishing the care to patients in some way. So in a meaningful and effective program to monitor this and protect against it is going to be essential for either the individual or the entity that is overseeing, or for example, a board with representation from each participant in the VBE in order to make sure that quality is consistent and isn't something that is being sacrificed in order to make sure that financial metrics work as a condition of having this kind of full financial risk relationship. And then finally, there's a requirement for these records to be kept for at least 6 years and be made available to the Secretary of Health and Human Services in the event of an inspection. And that is consistent with other record-keeping requirements and, frankly, less onerous than some of the other Medicare record-keeping requirements that can go on for up to 10 years. And this is probably more consistent with the requirements for HIPAA and HIPAA policies and procedures to be kept for 6 years when similarly dealing with the Department of Health and Human Services.
So next we'll talk about the downside, significant downside risk and the meaningful downside risk under Stark and AKS. This is less than full financial risk. They do allow for VBE models where the VBE or the VBE participants are allowed to receive certain financial and in-kind remuneration in exchange for accepting partial but not total financial risk. So Stark law defines these relationships as meaningful downside risk, and AKS defines these as substantial downside risk. One of the differences that I would highlight is under Stark, it focuses on the physician's meaningful downside risk, and so we'll talk a little bit more about that. But again, the standards between these two are fairly similar. So for the value-based arrangements with a meaningful downside financial risk to the physician, the key is that the physician is at a meaningful downside financial risk, which is defined as the physician being responsible to repay or forego no less than 10% of the total value of the remuneration the physician receives under the value-based arrangement. Now, a couple of items in the final rule are different from what was originally in the proposed rule. So first of all, this phrase "or forego" is new. They added that to make sure that, there may be situations where the physician simply does not receive the total potential remuneration under an agreement at the end of the year because quality measures were not met, for example. The other major difference is the proposed rule had suggested a 25% meaningful downside risk for a physician, and many of the commenters were concerned about that because there was a fear that physicians, particularly physicians who had not participated in value-based arrangements previously or worked on quality of care incentives that had an at-risk component, would be reluctant to participate in an arrangement where a quarter of their compensation was at risk. In the case of an individual physician, it's not the same as an enterprise. It's an individual physician with his or her own personal bills to pay, and so having a quarter of your compensation, albeit the compensation under that particular arrangement, is a lot to ask. One of the things that they pointed to in implementing this rule is in 2018 there was a Deloitte survey that indicated most primary care and specialty physicians were willing to tie about 10% of their compensation to quality and cost measures. That was something that there was data supporting physician comfort with and willingness to participate. And so that's the number that they landed on, 10%, which I think is something that you currently see under alternative exceptions that physicians are willing to participate in. So here's where we start to differ a little bit from the full financial risk. There's more requirements for writing. So the second requirement for the meaningful downside risk to the physician is that the nature and extent of the risk be set forth in writing. The methodology used to determine must be set in advance of commencing the value-based activities. The remuneration must be or results from value-based activities undertaken by the recipient. It's not an inducement to reduce or limit medically necessary services. It's not conditioned on referrals of patients who are not part of the target patient population. And again, the records must be kept. So an example of how this methodology requirement could be met is if you are requiring your physicians to complete these patient assessments. You could say, we're going to pay you $10 for each patient assessment that is completed. And if midway through you realize that amount needs to be increased, you could say increase it to $12 per patient assessment, but that would need to be changed and documented in writing before the commencement of that particular activity. So things to be alert to. There is an opportunity to modify and pivot, but it does need to be documented in advance of actually undertaking those activities. So finally, for those situations where there is a condition that the physician's referrals are to a particular provider, practitioner, or supplier, again, that needs to be in writing, and there needs to be this carve-out where patient choice or the best interest of the patients in accordance with the insurer or physician's judgment is going to trump that requirement. And so that's consistent with the other value-based exceptions as well.
And then the anti-kickback statute safe harbors very closely follow what's set forth in the Stark Law exceptions. I think the biggest distinction between them is that the AKS, as Amber pointed out, defines it as substantial downside risk. And then there's 3 different standards for what triggers that obligation for it to constitute substantial downside risk, in addition to the 8 other criteria that were previously discussed. The 2 main options that are percentage-based is that there is a 30% risk of loss for an entire continuum of care that's being provided, and set out is item number 1 in this slide. The substantial downside risk would be at least 30% of any loss based on a comparison of current expenditures of all items and services furnished to a target patient population against bona fide benchmarks to approximate the total cost of care. So that would most frequently happen in a primary care scenario, or potentially for a hospital where you're looking at the entire cost of the care, and not in contrast to the second option, which is taking a 20% risk of the total loss based on a specific episode of care, which would be, for example, a joint replacement or some kind of procedure such as a cardiological event, or potentially an organ transplant or something else that has a defined episode of care with a follow-up period after the fact. So there's slightly different standards for that, just based on the exact metrics of what the services and procedures or other items to be provided would necessarily be. So it depends on the unique factors of the practice and what would be the targeted value additive activity and how that would relate to the 20 to 30% downside risk, and whether it would make more sense to define it as episodic care or being the entire continuum of care for that patient population. The third option draws a little bit closer to traditional capitated payments, which is a prospective per-patient payment that is designed to produce material savings and paid at least annually for a defined set of services or items furnished to the target patient population, anticipated to satisfy the cost for those defined items and services. So again, there's no true-up provision at the end. It's a good faith estimate of what the costs of providing those services would be. And then at the end of that year, or close to the end of that year, there would presumably be an opportunity to renegotiate and figure out what the cost would be for the subsequent year. This is similar to, but distinct from, payments that are made under an accountable care association or an ACO. There are specific, as noted earlier, there's a specific safe harbor that was added for that as part of this most recent final rule that we're not talking about today. But similar to that, there's a number that's set in advance, and it is paid on that basis to the entity without taking full financial risk. So there is some opportunity for a potential true-up. And then, as Amber noted, there is an opportunity for things to be evaluated throughout the year and for the scope and the number of value-based activities to change in order to meet the standards of what the relationship would be between the parties and to make sure that the compensation is reflective of the services that are being provided. Additionally, there's specific contractual terms that are required for the safe harbor. As mentioned before, the contract has to be in writing, signed by the parties. It has to set out what the material terms are, and it has to have a duration of at least 1 year. There are some other interesting distinctions that exist within these within the safe harbor between the 20 to 30% percentage-based risk agreements. Namely, a party can enter into a contract with a wind-up time of 6 months prior to assuming any downside risk. So a company or a VBE can enter into this kind of a contract and start being paid as if it's taking risk without actually taking it, as long as it begins or is anticipated to begin taking that risk within 6 months from the date of signature. And finally, the VBE participants cannot make decisions to direct referrals to they can't prohibit VBEs from making decisions to the VBE is restricted from making decisions that would restrict referrals to providers that are not participating in the VBE, or restricting their ability to make referrals for specific services, except where those referrals are controlled by an HMO or a comparable organization, and they have to respect the desires of the patient with respect to making those decisions. So the referrals can't necessarily be captured by the VBE, so the patients can't escape the VBE. And it's one of the requirements for patient care and making sure that the providers don't end up directing the scope of patient care and overriding what the desire of the patient is while receiving this kind of care under this model.
All right, so the last exception is perhaps the most documentation and process heavy. So starting out with the Stark value-based arrangement, the very first element requires a signed writing that describes all of the value-based activities to be undertaken, how those value-based activities are expected to further the value-based purpose or purposes of the VBE, the target patient population, the type or nature of the remuneration, the methodology used for remuneration, and the outcome measures, if any, for assessing the recipient's performance. And so, as you can see right up front, there's a significant documentation that is required, and there is additional documentation and actions required throughout the duration of the arrangement. So if there are outcome measures, they must be objective, measurable, and selected based on clinical evidence or credible medical support. Those outcome measures can be improvements in or maintenance of the quality of patient care, or reductions in the costs to or reductions in growth in expenditures of payers while maintaining or improving the quality of patient care. So the patient care is always key. It has to hold steady or improve. Any changes to the outcome measures must be made prospectively and in writing. That is an option for things to change mid-arrangement. And then the methodology for determining the remuneration is set in advance of beginning those value-based activities. Again, we're to those common core elements of the remuneration is for or results from value-based activities. There's a record-keeping requirement, and then this is a requirement that we see in many other Stark exceptions, but it's the first time we've talked about it today. The arrangement must be commercially reasonable. So that is a term that has troubled folks in healthcare for quite some time. There is a revision to that definition that we didn't cover earlier, but I think it is relevant when talking about value-based arrangements. It means that commercially reasonable means that a particular arrangement furthers a legitimate business purpose of the parties to the arrangement and is sensible, considering the characteristic of the parties, including their size, type, scope, and specialty. Now, part of why commercially reasonable has been troubling is because there has been this concern that if the arrangement does not result in a profit for one or more of the parties, it is immediately suspect as being something other than commercially reasonable. And we know from various actions over the years that there are cases where a particular arrangement is not going to result in a profit. So, for example, a new physician who's onboarding, they may not be profitable in their first year because they're ramping up their practice. The nice thing about the new definition is that it specifically states that an arrangement may be commercially reasonable even if it does not result in profit for one or more of the parties. And so that is a refreshing change to make that clear. It doesn't get rid of the requirement that it's commercially reasonable, but it takes into the account the fact that it's not just about money when we're talking about healthcare in our communities. Monitoring. At least once a year, the parties must monitor. Have the parties furnish the value-based activities? Will continuation of those activities further the value-based purpose, and what progress toward outcome measures, if any, has been made? Now, this is the tricky part. If at the end of the monitoring, the parties discovered that the value-based activity is not expected to further the value-based purpose of the enterprise, then they must terminate the ineffective value-based activity. There is a grace period. The parties, if they're going to terminate the arrangement, they can continue for 30 days to wind down. And if they're going to modify the arrangement to eliminate that ineffective activity but continue with other activities, they have 90 days to modify that agreement. Now, it's good to have some time, but I would say that that's still a pretty short period of time for everyone to get together and modify the agreement. But something to be aware of, value-based arrangements are going to have quite a bit of documentation on the front end, and then will require monitoring and potentially new documentation. And then finally, outcome measures, separate from value-based activities, but if there are outcome measures and the parties determine that it's unattainable, then they must terminate or replace that outcome measure within 90 days. Finally, we get to some of those core elements again. We're running out of time, so I'm going to skip through them. You've heard them several times now, and we will move to the AKS care coordination.
Thanks, and I'm just going to run through some of these changes that happen with the AKS. The care coordination agreements are very similar to the value-based agreements that are value-based arrangements that Amber was just discussing. The main issues are that two or more VBE participants come together and they agree to coordinate as to patient care. Now, unlike the prior arrangements we were talking about, which had to do with the exchange of money, care coordination agreements only apply to in-kind remuneration, not the actual exchange of funds. Now, this is still significant because there are valuable services that can be exchanged, and this is often something where people who don't have the advice of sophisticated counsel think, well, I'm not exchanging any money. Why can't I do this for somebody? And I've had more than a few people come to me and say, well, if I'm doing this for someone, if I'm providing the service, it shouldn't implicate the anti-kickback statute, and they're wrong. It's still valuable. It's still consideration. Under any other contract terms, it would still be considered valuable consideration to perform a service for someone, even without the actual exchange of money. So the same logic applies here, but the coordination agreements are simply something that covers the in-kind value of the services that are being provided, such as one member of the VBE providing billing for all of the others, or providing patient scheduling or other services like that that have monetary value, but there's no actual exchange of funds happening. And this provides an opportunity for the entities that work closer together and to achieve the kind of clinical integration that is an area of concern when putting together, for example, a clinically integrated network or an independent practice association that the DOJ and the FTC tend to look for when they're performing their antitrust analysis, and that the Department of Health and Human Services would look to as well to make sure that it's a bona fide arrangement that is providing services that are designed to benefit the patient rather than the providers or facilities that are involved. So this is an important gap filler to deal with something that otherwise would have been prohibited by the broad language of the AKS and the kind of remuneration that is prohibited under it. So the new safe harbor creates conditions for value-based arrangements that are similar to what the Stark Law provides for, as well as Amber discussed. A value-based arrangement is defined as an arrangement with the provision of at least one value-based activity for a target patient population to which the only parties are either the value-based enterprise and one or more of its VBE participants, or the VBE participants in the same value-based enterprise. So they can come up with arrangements, and it's fairly open-ended in order to allow for that level of coordination and the sharing of this kind of in-kind service allowance that otherwise would have been prohibited. So if there's one member of the VBE that has a very good administrative operation or has a very good front of house, it can extend that out and confer that benefit to other members of the VBE and other participants within the VBE arrangement without violating the anti-kickback statute in a way that otherwise would have been prohibited and would have required remuneration for those in-kind services so that nobody was getting anything for free. Now, there's an important monitoring difference between the AKS and for Stark. I will just point to it here. It's fairly minute. Where the Stark is a little bit more, Stark Law exception is a bit more restrictive in terms of what is required by the monitoring and the requirement to terminate the agreement than what is permitted by AKS. It's fairly specific, so I'll leave that to everyone to look at for their own reference if they're inclined to do so. But there is a requirement. The Stark Law has a shorter turnaround time than the AKS does and is more restrictive, again, owing to the strict liability nature of that statute and the nature in which its exceptions are construed. Turning to the latest and the last part of the presentation today, one of the main additions to the older safe harbor that I mentioned at the beginning of the presentation has to do with the addition of outcomes-based payments to the the anti-kickback statute safe harbor for personal service agreements and management contracts. Now, normally there were just 7 requirements for those personal service agreements or management contracts to satisfy. Now there are 2 entirely new sections to that safe harbor that address the allowance of outcome-based payments and then other general safeguards that need to be observed for the safe harbor to apply. So these safe harbors that were added for the outcomes-based payments are very close to the kind of requirements that we have been discussing this afternoon with respect to the the full financial risk agreements and also the substantial risk agreements in terms of there being documentation of the satisfaction of the various criteria that must be met in order for a party to fully comply with them. For example, there are 8 requirements to comply with outcomes-based payments. The measures for what the outcomes will be must be set in advance. They have to be based on quantifiable benchmarks and informed by medical support or clinical evidence that actually measures the improvements in patient care or material reduction of costs or expense growth without loss of care, tying back to what Amber was saying earlier about holding the line in patient care if the goal is to control the rate of growth of expenses or to eliminate expense growth entirely. The methodology for determining the aggregate compensation has to be set in advance, consistent with the existing safe harbor, and it must be commercially reasonable, consistent with fair market value, and cannot directly account for the volume or value of referrals for other federally compensated business. Like the normal safe harbor, this has to be set out in writing and defined in advance. It has to be signed by the parties with a duration of at least 1 year. However, there is an opportunity for corrective action to be taken within that 1-year period to allow for compensation for progress towards those benchmarks or for recoupment of what would end up being an overpayment from a party that was not performing its obligations under this kind of outcomes-based arrangement. The other consideration is that the agreement cannot limit a party's ability to make decisions in their patient's best interest or to induce a party to reduce or limit the medically necessary services it provides. The services they cannot promote or counsel a business arrangement that violates state or federal law consistent with the existing safe harbor. And the performance of the outcomes measures has to be monitored throughout the year, including significantly and explicitly quality of care that is rendered to patients. And then the benchmarks and compensation can be assessed throughout the year and allow for either payments to be made for progress or for payment amounts that haven't paid to be recouped if there's not progress being made or if those benchmarks are not being met. And then finally, there are policies and procedures that have to be in place to correct material performance failures or deficiencies in quality of care. So this isn't something to just be put together to make sure a certain benchmark is met, such as bring me X number of patients and therefore you will receive more money, which would raise state law issues with respect to licensure as well. The requirement is that there are policies and procedures in place to contemplate and embrace the specific requirements that are informed by clinical data and by other research to ensure that the participants in the agreement are meeting their requirements. And then in addition to understanding and defining what those requirements would be, there are policies and procedures in place to ensure that there's corrective action that is effective and appropriate being taken to drive the party that is deficient in its obligations towards meeting those obligations based on that medical literature. And how that would work would depend on exactly the nature of the relationship and what services are being provided. But it's not something where the parties are designed to just put something so that there's an additional bonus allowance into a contract arrangement. This is designed to be a bit more methodical, a bit more long-term and longitudinal, and intended to help parties work together and achieve common goals over the long term rather than to provide a little bit of additional compensation to a contractor in a more loose arrangement. And then another addition to the safe harbor for these personal service agreements is subpart 3. And these are just general catch-all provisions that were added onto the end of it. And the three most significant ones are that outcomes-based payments can only reward an agent for achieving appropriate measurable outcomes or can recoup payments that were made after it becomes evident that these benchmarks are not being met. Is kind of an equalization. Normally, true-ups work to bring a party up to where they should be, but they can work in the other direction as well, where if a party says that they're going to meet certain goals and they fail to do so, they can have to disgorge a piece of that compensation back to the party that engaged them. Additionally, there are restrictions similar to value-based arrangements, and the payments cannot be made to that wide range of individuals that we previously discussed, which include pharmacies that are engaged in compound pharmacy, pharmacy benefit managers, and the whole host of DME participants. Finally, outcomes-based payments have to be based on actual medically significant criteria. They cannot be based solely on cost savings or patient satisfaction, which are more qualitative and are more susceptible to manipulation based on, for example, push polling and the questions that are being posed to patients to measure their satisfaction, as opposed to the outcomes that are measured in quality of care in the outcomes of patients based on their medically significant criteria. So thank you for your patience as we went through all of this. We know we still have a great deal of people participating here and watching along. We want to hold the floor open to questions, and then also note if the question is too significant or if it's something that requires a more involved answer, we certainly would welcome any kind of email correspondence in order to respond to those questions and make sure that you receive the answer that you want and deserve based on the quality of the question. Additionally, I would suggest if anybody has a question that doesn't lend itself to an email, if they could write it into the chat, we would be able to respond to it there if it's something that we can see quickly. I received one question. I'm going to read it out just so we have it there, and I see Amber is still available to help me with this. There's a question. A nurse practitioner and a fellow patient in a skilled nursing facility has a question about an increase in depression among the residents. There's a question about referring the residents to counselors or social workers. There aren't enough counselors and social workers to meet the need based on the acute increase in depression among residents at the facility. If the goal was to purchase a counseling business or become a partner in one, would there be the possibility for referral of the patients within the counseling business, would there be the need to set up a VBE? So the ability to purchase a counseling business or become a partner in one would be determined by the law of the state where this is occurring. So it's difficult to give a specific answer as to what would be possible in that respect. There might be licensure requirements, and it depends on what the laws of that jurisdiction would be in terms of whether this person has a license and if there's the ability to have non-licensed ownership of such an entity to become a partner within it. In terms of whether that would be possible to set up a VBE, it might be easier to set up the VBE without overlapping ownership, to put this together the same way that one would a clinically integrated network and set up this kind of relationship so that they would qualify, put the policies and procedures in place in order to do so, and then just making sure that these are going to be compensated, because there is some limitation on the amount of mental health that would be compensable, certainly under Medicare, a little bit less so under Medicaid, in terms of making sure that these would be covered services that would be compensable to put that together. So it's not something that can be disregarded out of hand, but it would require a little bit more information that is currently there. And then in order to figure out exactly what would happen, it depends on who would be making the payments, and if it would be a kind of coordination of care arrangement in the first place, which would be a little bit easier. And I think figuring out what the financial ramifications would be, that would depend on which avenue to go down with the AKS. So something like this, it requires a little bit more information, a bit more thought, but I'm not willing to sit here based on the information I have right now and say it's impossible and not something that could be pursued.
And I think that call out about the increase in depression is a really great example of something that could be a value-based purpose. I'm seeing another question on here. It is there an issue for a physician to own stock in the company they work for while also seeing patients referred by the company? And that says, for example, they work for a telemedicine company and also own stock in the company. And so that's going to fall under either the group practice or one of the ownership exceptions, potentially. That's where I would look to see if it meets those criteria. And we did not cover that today, but that would be something that you'd want to look to, not just those federal regulations, but then additionally any state-specific laws, because some states do have a state-specific version of the anti-kickback law or other sort of fee-splitting arrangements. Jay, do you have anything to add?
Yeah, that scenario sounds like something that should be able to be made compliant if it isn't already. If somebody is a member of a group and they're probably going to be an employee, it depends on a couple other factors as well, but it's very common if there's different people working together. If there's institutional investors involved in the telemedicine company, that might make things a little bit different. It depends on the state law. Certain states are more comfortable with non-physician ownership of physician entities or non-physician ownership of entities that directly employ physicians than others. Speaking to Nevada, a situation similar to this where the physicians or rather an entity is wholly owned by physicians and it's an S corporation and the physicians are all working employees of it in addition to shareholders. With adequate documentation, I would feel very comfortable with an arrangement like that, but I would want to see what the underlying documents look like.
I'm not sure if I'm seeing any other questions, but I think one other item to be aware of, we do have red lines prepared of these two sets of rules on our website. If you want to take a look at the changes that were made all in one document, go ahead and take a look at those. I'm not sure if we've got a link to that available that could be shared in the chat, but certainly on our website, on our blog, you can find the red lines to the regulations.
And with that, thank you, everybody. We appreciate your time and attention consideration today. Please do not hesitate to send an email to the organizers of today's presentation if you have any additional questions, and we will respond as soon as we are able.